Hello, I'm Tom Carpenter, and thank you so much for joining us today. I'm here with my friend and colleague MJ Williams of the Wissing Miller firm. And MJ, if you want to say hello to folks.
Absolutely. I am so thrilled to be here. Thank you so much for the invitation, Tom. Like Tom, I am an attorney, and my focus is throughout my legal career has been on all aspects of intellectual property. And that's why Tom has invited me here today. Tom, do you want to say a little bit more and then I'll get deeper into my intro?
Sure thing. Well, I'm very happy to be hosting this. I'm the managing attorney at Carpenter Law Group, PC. We represent clients in the travel and tourism industry, many small travel agencies and tour operators. And those of you who know me know that in addition to my law practice, I also own an agency. So I do the same things that all of you do pretty much all the time. So um, I see Shayla's already in the comments saying hello, so I'm assuming that we're connected. But if you have questions or want to give a shout out at any point in time, and there's Sarah. Hey, Sarah, how are you? So you can just type something into the comments on whatever platform you're viewing this, and we'll get that. We're going to try to do questions and answers at the end, and I'm just going to let MJ do her little introduction. So
Thank you again, Tom. Really thrilled to be here and with everybody who's joined in this afternoon. As mentioned, my practice is intellectual property, largely trademarks and copyrights. And throughout the years I've been doing this, I've represented startups, everyone from startups and individuals to global corporations in pretty much every field. But over the past few years, I've been regularly working with travel advisors like yourself. And in doing so, it's come to my attention and my grave concern that there is more infringement, particularly trademark infringement, within the travel field than I've seen in any other field. And that's really the genesis of my being here with Tom today, is that we both decided that it would be really important to share information to sort of like make an intervention within the field in order to improve conditions within it. Um, Another reason, I'm just going to mention this as a personal note, why being here is near and dear to my heart, is that before I was an attorney, back when I was a teenager, Tom, you might know this or not, that one of my first jobs was working at my mother's travel agency back in the olden days when you needed to hire a teenager to spend hours and hours filing the paper brochures. So I really, it brings a lot of joy to me to represent travel professionals.
that's awesome. That's great. So should we get a few professional responsibility disclosures out of the way, just briefly? So I think this is our next slide probably, but essentially we are, this is for informational purposes only. We're not intending to provide any specific legal advice about any particular issue. By viewing this webinar, we're not creating an attorney-client relationship between your business and either of our firms, unless we already represent you, in which case you can call us offline. We're happy to give you all the legal advice you want. And this also might be viewed as attorney advertising, so we'll just make that disclosure out of the way. And then I'm going to turn it over to MJ and let her do the rest of the presentation, and I'll keep an eye on the comments. If there's anything that comes up that we need to clarify, I'll jump in at that point.
Thank you, Tom. So, as Tom said, this is to share information. It's not legal advice, but we do hope it's relevant to you. We're sharing information and also best practices. And among my goals, or our goals, is to demystify intellectual property for you, the legal concepts and the legal language around it, and with a mind to really empowering you to be strategic about use of your intellectual property and uses of others, intellectual property that belongs to others. So in that vein, just going to spend a few minutes just like taking apart what is intellectual property. Like, let's unpack that. And above all, and I think this is really important, it's been important for how I think about intellectual property, and I think it's very important for business owners like yourself. It's, in essence, it's property. It's property like your computer equipment. It's property like your car. It's property like your home or an office that maybe you lease. And like those forms of property, it's owned by somebody and it's controlled by that owner. That owner may, like you may invest in maintaining your computer equipment in your car. Similarly, you'll do so with your intellectual property. And you will also, I'm sure, secure the use of those forms of property from others that you do not authorize to use it. You're going to make sure that nobody uses it without your permission. You're going to make sure that nobody takes it without your permission. Talking about, computer equipment, your car, your home, and so on. Same with intellectual property. And that's because these are valuable forms of property. So what makes this intellectual is the actual content. So when we're talking about certain terms, certain wording or symbols, you're talking about trademarks. That's intellectual property. Artistic works are another form of intellectual property that are protected under copyright law. Inventions and certain designs are protected as patents. Business information, if it's proprietary, in other words, like a form of property, and it's kept secret, like famously the formula to Coca-Cola, those are trade secrets. Those are another form of intellectual property. And even one's appearance used in a commercial context is a form of intellectual property that its owner, the person whose face it is, gets to control. So today we're going to be focusing on trademarks and copyrights within the United States. I've created a cheat sheet here. I am not going to go through all the details on it. I welcome you to take a screenshot. If you'd like copies of these slides, feel free to reach out to Tom or me. But what I want to point out here is just get us on the same grounding. What are the differences? What are between trademarks and copyrights? I think you all know it, but it's really common, even among attorneys, trust me, to confuse what is a copyright and what is a trademark. So trademarks are typically words or a symbol, like a certain design, or a logo, which might mix together a graphic design and wording. They can also be other forms which are less common, like even the sound of the Harley Davidson motorcycle is actually eligible for trademark protection. So they're words, typically words, symbols, and logos that are used in connection with the sale of goods or services. They're used as like a stand-in. They're used to symbolize particular goods or services, and they're used in the marketplace to sell or offer those goods or services. And the reason why trademarks are protected in the United States and around the world is foremost to regulate the market. It's to prevent chaos within the marketplace. It's to protect all of us who participate in the marketplace from being like confused between like what is what. And trademark law like pays a lot of attention. A lot of its purposes is to protect consumers from confusion in the marketplace, and also additionally to protect trademark owners. Now, when we're talking about copyrights, think about creative works, novels, film, recorded music. For you, it would be the text on your website, the photographs, the graphic design of your website, drawings that you might have on your website. And copyright protection begins as soon as a work is created in some type of tangible form. As soon as words are put on a page, typed into computer, paint on a canvas, and so on. And the reason why copyrights are protected in the United States, they're actually the basis for copyright protection in the US is in the US Constitution, is because we've all decided that we as a people, we as a society will benefit if the creators of these important works or of, any type of creative work have some type of comfort that when they share those works publicly, when they put it on the when they publish it, when they put it on the web, that they have some type of recourse if that work is taken without their permission.
So MJ, just to kind of distill the last couple of slides, what I'm hearing is that for travel advisors, an agency owner, your name of your business, your brand, your logo, those are things that are intellectual property. They belong to you, and those would fall under the category of trademark. Whereas your website that you've created for your business would be something that would be copyrighted. Is that
absolutely right? Your trademark should be on your website, but all the other content, photographs, drawings, the text, the copy would be eligible for trademark protection.
or for copyright protection?
Excuse me. Yes.
Yeah.
Thank you. So glad you're here, Tom.
No worries. It's late. It's a Friday afternoon, so we're all going to be a little crispy.
And that's the need for this cheat sheet.
Yeah. Okay.
All right. So today, we are going to focus above all on trademarks. We're going to go through trademark selection, protection, enforcement, and have a short chat about trademarks as business assets. So let's start where we should all begin, which is in choosing your mark, trademark selection. And I imagine, Tom, your travel business already has a trademark. I'm sure almost everybody who's on this call who has an operating travel business already has a trademark, but somewhere down the line, you may choose to rebrand. You also might develop a certain line of services, maybe even some goods that you will adopt an additional trademark for. So when you do that, the two main considerations you'll need to keep in mind when you're brainstorming about what is a great trademark for your goods or services is, number one, is it actually a trademark? And one thing that I think is important to clear up, now I think it is somewhat typical among travel advisors that the name of their LLC or of their corporation, which is called a trade name, your business name, is the same as your trademark. But these are different things. A trade name, the name of your LLC, does not necessarily have to be your trademark. You can name your LLC whatever you want. It has very little requirements. It just doesn't have to, it's registered in a particular state. Simply can't choose the name of an LLC or of a corporation that is identical to another one within that state. But through that registration process and all the things that you go through for your LLC or your corporation, that has nothing to do with trademark rights. And in fact, the name of your business does not have to be your trademark. And in fact, among businesses, it's pretty common for the name of the business to not be public facing and to be entirely different. Like, for example, does anybody on this call, have you ever heard of Reckitt Benckiser? Probably not. But you have heard of Lysol? You have heard of Airwick? That's Reckitt Benckiser's trademarks for its consumer products. And for obvious reasons, they don't use Reckitt Benckiser as their mark because it really is not that catchy. And no one on this call probably even knows how to spell it. I certainly don't.
I was just going to say, so for example, in my travel business, my LLC is Carpenter Slivkin LLC. And then we have a doing business as Huckleberry Travel. So we put Huckleberry Travel out to the rest of the world as our trademarked name. But even if we had registered as Huckleberry Travel LLC, when you register your LLC as a name, that doesn't actually protect your trademark. Am I getting that right?
That's correct. By registering the name of an LLC, even the one that you plan to use as your trademark, does not give you trademark rights. And it certainly has nothing to do with registering a trademark. That's registering your business name only.
Okay. And I'm seeing a couple of comments come in from Bettina and Maria with some questions. We're going to take questions at the end, so we're not ignoring you, FYI, but we'll definitely come back to these things.
Thank you so much for your patience with that. There's just a lot of material that I want to get through and just want to make sure that we have time to do that. And I might answer your questions as we proceed. So when you are choosing your trademark, so number one, your trade name is not necessarily your trademark. What you need to do when you're choosing a name like Huckleberry Travel is that you need to choose a name that is distinctive. And it must be distinct from your services. And I'll give you an example so this will be much more clear. So let's say you have a friend who's seen the success you've had, how much fun you have with your travel business. They want to open up their own. So they say, I'm going to make it easy for me. I'm going to make it easy for everybody else. I'm just going to call what I do Florida Travel Services. They're welcome to do that, but they are not, that wording is not going to be entitled to trademark protection. That is not a trademark. And that's because there is no way that Florida Travel Services could distinguish those particular set of services from the hundreds and hundreds of other travel advisors that operate within Florida. In addition, there's a certain wisdom to trademark law because you cannot gain exclusive rights to wording that your competitors need to use. So for example, all the other travel advisors who operate or provide travel services within or to Florida are obviously going to need to use the word Florida and use the word travel and use the word services. And so those terms cannot be locked down by one owner. Tom mentioned Huckleberry, his business, Huckleberry Travel, and I want to just talk about that for just a moment or two, because that's a particularly strong mark. And the reason why that, in my view, is a strong mark is because Huckleberry is exceptionally distinct from travel services. The term Huckleberry has no inherent reference, no inherent meaning related to travel. And all the association among Tom and his partners' clients and prospective clients and everybody on this call is beginning to make between Huckleberry Travel and travel services is due to the hard work that Tom and his partner have put in to market their business. And trademark law rewards that hard work by making exceptionally distinct marks that are very different, that might be arbitrary, might even be invented terms, reward those types of marks with broader protection. So that's something to keep in mind, something for you to be considering when you're brainstorming about a mark. The other really fundamental, important consideration is whether the mark is available. You will not gain trademark rights if you select a mark that is similar to one that's already used by somebody else to market similar goods or services. Trademark rights, as I think I've been underscoring, are exclusive to one owner. That helps regulate the market to make sure that there aren't like multiple Huckleberry Travels out there, so nobody knows who's actually offering those services. Interestingly, there also trademark rights do have some limitations because Huckleberry used for, let's say, a publishing house can exist in the market with Huckleberry Travel because there's such different uses that there's really very unlikely that anybody would be confused. And we'll get into what confusion means in a trademark sense in a few minutes. But back to like figuring out whether a mark is available, what you'll engage in is called a clearance search. And that is to demystify this. It's largely like checking online. Searches can also be conducted in other sorts of public resources like the US Patent and Trademark Office register. It's at this point that I would point out very honestly that you may want to work with an attorney, because deciding whether a mark is similar to another, whether the services are similar to each other is really a legal analysis. An attorney will be able to help you parse through and make a determination of whether a mark is available or not. So onto trademark protection. So how do you gain trademark rights? In the United States, and I've mentioned this briefly when we were on that cheat sheet, you gain trademark rights by using a mark commercially. Trademark rights in the United States are born and maintained by using a mark to sell or offer certain goods or services. In the United States, you also have the possibility of registering your trademark rights. And those trademark registration offers an important set of benefits above and beyond the protections that you have simply by using your mark commercially. Among those benefits are, as soon as you register your mark, you automatically get nationwide rights. The other is that that piece of paper, the registration certificate, is proof that you own the mark. It's also proof that your mark is valid. After several years of registration, you can also claim that your mark is incontestable. In other words, its validity can never be challenged, which is a very important benefit. And above all, I've in the past, I've understanding, especially with new businesses or small businesses, you do have protection under trademark law in the United States simply by using your mark commercially. But since we are all now conducting our business online, the trademark registration is honestly increasingly important, because if you want Meta, which owns Instagram, which owns Facebook, if you want the owner of Yelp to go to bat for you when somebody opens up an account that infringes on your trademark, you need that trademark registration. Meta's not going to be not willing to navigate rights in the marketplace. It needs that registration certificate that proves that you're the owner, that proves you have a valid mark to take action against an infringing account. An infringing account. The other thing that I just want to mention, just in passing, is the US is unique worldwide to grant trademark rights simply by using a mark commercially. Everywhere else in the world, except for, I believe, the Philippines, everywhere else, trademark rights are born through registration. You absolutely must register a mark outside of the United States to have any form of trademark protection. So another important consideration is around maintaining your trademark rights, because trademark rights don't necessarily last forever. They can weaken over time, and they can even be lost. Number one, if you don't use your trademark, you must use your trademark in order to maintain those trademark rights. And in terms of best practices, using your mark properly will not only help you maintain your trademark rights, but will also help your mark gain in value, gain in strength over time. And proper use is using your mark prominently, using it continuously, using it consistently, and using it extensively. And these recommendations should be totally aligned with marketing, because trademark rights and marketing align frequently. And the goals of both are to build an association between your mark and your particular goods or services, what you do, what you uniquely offer, to build that association in the minds of your clients and your prospective clients.
So, so just to kind of repeat back kind of what I'm hearing, in the United States, if you set up a business name, you set up a website, you start operating as, we'll just say, Huckleberry Travel, even if you haven't registered your trademark, you still have a trademark. Just by virtue of the fact that you're using that actively, you're branding yourself, you're marketing yourself under that business name, you got a trademark. But registering that trademark is the next step, which provides you with added protection, so that if somebody else starts a business called Huckleberry Travel, by having that registration, I can beat that down so that there's not confusion and people think they're talking to me, but they're actually talking to some Yahoo who started a business with the same name as mine, right?
Exactly. I mean, you do have, not only do you have a trademark by putting your name out there and offering services such, your travel services, but those rights are also enforceable, but they're much more complicated to enforce if you don't have a trademark registration, because that piece of paper, which takes a lot of effort to get, that piece of paper automatically proves that you're the owner and that you have a valid trademark, and that
Yeah.
your rights are valid nationwide.
And we did have a question that's actually relevant on this point, and it's a quick and easy one to answer. But Janessa is just asking me, Tom, do you offer trademark services? And the answer to that is I do not, because trademark is such a specific area of law that I refer my clients to MJ, because she is, this is what she does. This is her in her wheelhouse. And so if you're looking to have somebody do that work that she was just talking about, getting that piece of paper, getting that registration, MJ can definitely help you with that. If you call me about it, I'm going to tell you to talk to MJ. So
thanks so much. Yeah, I mean, I hope you're getting the fact that I'm also like passionate about this. So be happy to work with you. The last thing that I just want to mention about maintaining your trademark rights is that you have an obligation as a trademark owner to police your mark. Remember, trademark rights are exclusive. And if you don't take steps to ensure that your exclusive rights are maintained, that you are the only one using that mark for particular sets in a particular category of goods and services, your trademark rights will weaken and eventually, as I mentioned, could potentially be lost. So when we're talking about trademark infringement, what are you enforcing against? This has come up already. You're enforcing against trademark infringement. And what I have up on the screen here is a legal definition that I think is important to go through. It's a bit of a mouthful. I'm going to read it at least a couple of times so that it sinks in. But it's a very precise definition of trademark infringement, which I think will be helpful for all of us. So trademark infringement is the commercial use of a mark in a manner that is likely to cause consumer confusion, mistake, or deception as to the origin of the goods or services. So breaking this down a little bit, trademark infringement occurs when somebody uses a mark to, on a website or in another form to offer goods or services in such a way that consumers are likely to be confused, to make mistakes, to be deceived as to who actually is offering these goods or services. And trademark infringement occurs when those terrible things like consumer confusion, mistake, or deception are likely to occur. They don't actually have to have happened for you to take action against trademark infringement. Like a very stark example of trademark infringement of when confusion was actual is that I have a client who offers travel services only to high wealth individuals. And she this year has begun to get calls, a lot of them, from really disgruntled individuals who are complaining that they want their money back, that they listened to a presentation about a travel club and they paid a handsome sum of money to receive all these discounts, and they haven't been receiving it, and they're going on, and she has to interrupt them and said, like, I never gave you a presentation. I don't have a travel club. I am so sorry this happened to you. And of course, this is highly disruptive for her business. And what happened is that travel club, not only are they probably not particularly great colleagues within the travel business, but in addition, they are using a mark that is so similar to my client's mark that people who attended their presentation and paid them a sum of money are calling her instead of them. That's an example of actual confusion.
Yeah, and MJ, you can just call that fraud, because those of us who own travel agencies, we all know that there are disreputable, fraudulent companies that are out there. And I think that goes back to the question that Bettina asked earlier in the chat about giving examples of trademark infringement. So you wouldn't want somebody to start a scam operation with a name that is remarkably similar to yours, because that's going to be a problem for your reputation if people confuse the two of you.
Absolutely. And it can also come up, it doesn't have to be this as horrible and scandalous a situation. Could be somebody who maybe is legitimately offering travel services, but thinks that if they add an S at the end of travels, and your Huckleberry Travels versus Huckleberry Travel, that they are not infringing on your trademark. And that's just simply not true, because you can't that puts way too much on your clients to distinguish between Huckleberry Travel and Huckleberry Travels. It's very likely that your clients or prospective clients would be confused about which business is which when they're searching for you online. And so that's another example of trademark infringement, is by using a mark that is so similar for similar goods or services that consumers are likely to be confused or make mistakes. So if it doesn't get to the point that you're getting deluged with really unhappy calls from really unhappy people, if you want to be proactive, what you should be doing is monitoring for trademark infringement. An easy, simple way to do this is to set up a Google alert. Set up a Google alert with your mark or your marks, and you'll get results, at whatever frequency that you want, and you'll be able to see if somebody else is using your mark online. Another, and this is again a best practice, I highly recommend it, is to use a watch service. These vendors are not very expensive, and most of them, I think, are using AI, and they're out there and they'll be able to find marks that not only are using similar wording, but also sound the same, which I think are harder to find through a Google alert. And they may also provide you with enforcement services. You also, at this point, if you do identify potentially infringing use, this may be another moment where you reach out to a knowledgeable, experienced trademark attorney to help you understand, is this really infringing, and what you can do. Among the things that you can do, you probably have all heard of a cease and desist letter. Cease and desist letter, to just unpack that, it's essentially a letter making a demand on an infringer to stop doing something, in this case, to stop using the infringing mark. Another way that you can address infringement, something that we've also made mention of, which is online enforcement. You can go on Instagram, they have a form that you use for trademark infringement. You can do that. You can engage in online enforcement if you have a trademark registration. Meta is going to require a trademark registration in order to have them go to bat for you. That's another form of enforcement.
And MJ, just one quick question.
Mm-hmm.
If you haven't yet registered formally as a trademark, you can still send a cease and desist letter, correct?
That's correct. Absolutely. You will probably in that letter want to spend a little bit of time demonstrating how and why you're the owner of that mark, how long you've used it, how extensively you've used it, because you can't just refer to a trademark registration certificate to prove your rights to it. But absolutely, because in the US, simply by using your mark commercially, you have enforceable trademark rights.
That's great.
And even if you do need to get to the point of suing in federal court, you don't need a trademark registration even to file suit. Again, I would highly recommend that you be looking at federal lawsuits, federal trademark infringement suits as as a strategy of last resort, but you can sue even if you don't have a trademark registration. It's a little bit more complicated because, again, you need to provide evidence that you're actually the owner, that your mark is valid, and so on. But you can sue if you have if you don't have a registration, or if you do have a registration. Trademark infringement is generally resolved through settlement. Y'all are business owners. You can figure this out. You're a business owner, and let's say you have gotten a cease and desist letter. It's legitimate. You've talked to an attorney. Yes, they do own the mark. Yes, they were first to the marketplace. It may be the most practical business decision is to, over time, with the agreement of the other side, migrate away from that mark and to stop using it. And you may then come to a settlement agreement where if you take certain steps, they will agree not to sue you. Another typical settlement arrangement is that if you, the two owners of marks, which are confusingly similar, but you realize that your client bases are really different, the types of services that you offer within the travel industry are really pretty much distinct, and you could come to an agreement where you set up terms and obligations on one another to stay in your separate lanes. And those are called coexistence agreements, which are a very typical way to resolve infringement. Another way to infringement is resolved through enforcement actions is by takedowns. That would be when Meta on Facebook takes down an account that you have made a complaint about, and they have decided that that complaint is legitimate, meets all their criteria, and they take down the account. You do need to go to federal court, and you go all the way to trial, all the way to judgment. You haven't settled along the way. You can obtain court-awarded monetary damages, which are generally the other side's profits that they earned by using a mark that infringes yours, and or the court will award what's called injunctive relief, which is a court order that the other side cannot use that infringing mark. So I just want to talk a little bit, and would love to hear your comments on this as well, Tom, about trademarks as business assets. I think you could agree that they are incredibly important for your business. It's essentially your calling card. It's the first impression you make. It's a lasting impression that you make. It's how you're known to your clients. It's how you're known to your prospective clients, how you're known to your vendors, to your competitors, and to your partners. Ideally, go ahead, Tom.
No, I was just going to say, I think of, protecting your trademark as part of your marketing plan, right? So in my business, when we launched our business, we did a lot of work to try to come up with, I think everybody kind of struggles with what are we going to call our new agency that we've just started. There are more and more people entering into the industry post-pandemic than ever before. And so, it's inevitable that you're going to have trouble kind of finding something that's distinct that really sets you apart from the crowd. And so, when I'll just tell this story, like when we were sitting around at home and kind of thinking, well, what are we going to call our business? And we batted around a few ideas, and we had a dog named Huckleberry. And I looked at the dog and I'm like, what about Huckleberry Travel? And that became the name of our business. And we like it because it has the connotations of being very authentic and down to earth. And, like from Tombstone, if you're looking for the right person for the job, I'm your Huckleberry. We found a logo that we really liked that was distinctive. And we have kept, in the same way that we've kept one foot on the marketing gas pedal to try to develop our client base, we've also kept one foot on the branding piece of that. We've got little enamel pins with our logo on it. And so when we go to trade shows and conferences, and we're wearing our pins, and when our sub-agents are also wearing those pins because they sell under our brand, suppliers remember us. And so definitely it is a calling card for your business. Your trademark is something that has value, and it's integrally connected to your branding. So taking off my legal hat and putting on my agency owner's hat, I think it's just really important to kind of really cultivate and develop your brand and make it distinct, because, there are lots of travel businesses and their name sounds exactly like three other, small variations, maybe things that can't be protected, but being distinct, going back to the thing that MJ was saying in the very beginning, is really, really important. So,
Now, you put it much, much better than I could have, so I appreciate that. And one thing, and again, I imagine that you'll agree and could probably comment on this. What's interesting, going back to the beginning, and I'd mentioned that trademarks are property much like your computer equipment or your car. Unlike those types of property, though, the more you invest in it, the more that you come up, have swag to give out and you find ways to get your name, your trademark out there, your mark increases in value. Whereas your computer equipment in your car and so on, we know that it depreciates in value. And so your mark is going to grow in strength. And, there may come a time, for instance, when you are looking at selling your business. Trademarks are like property and they can be sold. And if you have a strong mark that's registered, that you have ensured over the years, is that only you own it, you've enforced it, you've promoted it extensively, it's going to be a very, very, valuable line item when you're selling your business. And the other thing that I would, just like highly recommend as a best practice within the travel field in particular, is that you establish a budget line for trademarks in your business. And it can be absolutely twinned with your marketing budget. But you should make sure that you have funds that are being used to maintain your trademark, to invest in it, and funds that are available in case you do need to enforce it. Because it is unfortunately more likely than not that you will have to deal with a trademark infringement issue within this field.
yeah, and I know that a lot of people who are new to the industry, when you're starting a new business, one of the great things about the travel industry is that it's pretty easy to start a business without spending your life savings to get into the travel industry. On the other hand, it is unrealistic to think that you can start a business without making an investment in that business. And so, if you're looking to the lowest common denominator to get started, and not investing in things like your trademark, or like a good solid terms and conditions document, or a technology tool like TravelJoy or Turn or Travefy to help you be compliant with best practices. Those things, there's some money attached to that, and I think MJ and I both agree that we understand that new business owners don't have unlimited resources to just spend on a business that might be starting off as a side hustle or a part-time thing. But at the same time, I think it's important when you're starting your business to really be realistic about the fact that you're going to have to make an investment in that business in order to make it work.
And again, what is gratifying about investing in your trademark is that you're going to see the results of that in the short term and the long term, because those marks are going to grow in value. And and again, in the short term, the more that you use the mark, the more widely that you're going to be known within the industry.
Yep.
So going to switch gears if we can. We're now in like the 7th inning stretch. This is and just in just a few minutes, as quickly as possible, I just want to touch on copyrights, particularly for travel advisors. And Tom, you pointed that out a number of minutes ago. That would be copyrights that travel advisors use would be, or work that is eligible for copyright protection would be the text on your website, or other marketing collateral would be the imagery, the photographs, drawings on your website, or in other types of marketing collateral, and even their graphic design. And copyrights are granted to the individual who created that work. who created that work. And that individual who created that work is known legally as the author, even if it was paint on a canvas. They're known as the author, and they're protected under US copyright laws simply by creating that work in some type of tangible form. And like with trademarks, you can also register your copyrights, and you get a whole set of additional benefits from copyright registration, particularly if you register your copyrights before your copyrighted work is infringed. So there's an incentive built into the system to register your copyrights early, soon after they're created. And now I'm going to venture to say, I don't know if this is true for you, Tom, but I venture to say that pretty much everybody on this call who has a website, they have not taken every single photograph that you have on your website. And so you may not be the original owner, you may not be the actual author, the creator of those copyrights. And so in those situations, if you've done things, like properly, then you will have been made sure that you have permission to use those photographs that somebody else took, that somebody else is eligible for copyright, to own the copyrights. But you may have licensed use of those licensed use of those photographs. You're paying a certain fee so they can use it in a certain way in a certain length of time. And you've been granted the permission so that it's on your website. Or in certain instances, for example, if you work with independent contractors, if they take photographs when they're on a fam trip that is like spectacular and you all want it on your website, that independent contractor owns the copyrights in your photograph. You can, though, through a written agreement, have the copyrights in those photographs transferred to your business. Copyrights, like other forms of property, can be leased, or in this instance, licensed, and can be transferred from one owner to the other. And go ahead, Tom.
No, and I was going to say, and there are a lot of suppliers that have image libraries that they freely allow travel agencies to use, because you're the sales agent for those cruise lines and resorts. And so if you're looking for images that they will license to you for free, you can get those from suppliers for sure. But one thing, MJ, if you can just talk about this, because this comes up a lot, when people get a shakedown letter from some lawyer in Germany that says you're using my client's picture without permission. And a lot of times people reach out to me. I send them to you, but people reach out to me and say, do I have to pay this? What do I have to respond to it? Can I just ignore it? And how would you answer that question to somebody who says, I didn't realize I was infringing on this. I thought I had the right to use it.
That's a perfect segue. I wanted to talk about that and one other typical form of enforcement that is encountered among travel advisors. These shakedown letters are really common. There are law firms whose whole business is to use, I think, AI-powered tools to scrape the web to find their clients' photographs. If you do have any photographs on your website that maybe your web designer told you were royalty free but aren't, chances are you're going to be found out by one of these law firms, again, that are scraping the web and are finding all of their clients' photographs. If you do get one of these letters, copyrights, because they're meant to protect creators, offer them a very, very strong protection. Inadvertently infringing somebody's copyrights is no excuse. The legal term is that this is a strict liability. And in those instances, you may want to make sure that it is the same image that they're complaining about. it may be interesting to know whether or not they have a registration for that work, because the amount that they're demanding from you could be higher if they had registered that photograph before you had used it on your website. And often these are just a matter of negotiating down to a price. But what this means is that it is, incumbent on all of us, even lawyers, to make sure that any imagery that we use, that we actually have rights to do so. The other common thing that we see among travel advisors is that, and this is really unfortunate when it happens, is that I've had travel advisors come to me when they have noticed that somebody has essentially cloned their website. And, we live in this like copy paste culture with everything on the web. We think that we can just do it and we're going to get away with it. Or some of us think that we can copy and paste and get away with it. In those instances, I have worked with the travel advisor and have sent cease and desist letters to the infringing individual who has essentially copied either the text from their website, or maybe even like lifted the text and lifted the imagery. But it's these shakedown letters, and then others who, just like are like so attracted, they think that everything that you've done on your website is so good that they just can't help themselves and they take it. But they really can't. The copyright laws protect you from that. So I think, we're now at a point, and hopefully it looks like we have about 10 minutes or so for Q&A, which I'm really excited about.
For sure. So let's just take a couple of these questions. So Bettina, who's watching on LinkedIn, just asked if we could give some examples of trademark infringement that we've seen. I'll give one. I had a client that had a business name that reached out to me, and never actually hired my firm to do her terms and conditions or other information. And then, but she was in my system because she filled out an intake form, and we did the complimentary consultation, and I tracked that. And then a year or two later, somebody with a very, very similar name reached out to us, a similar business name reached out to us. And my associate, Brandon, who is crushingly awesome, I don't know if he's watching right now, but shout out to Brandon. He was doing some work, and that was on an hourly rate that was billable, and he was logging his time in the system, and he logged his time to the wrong client record because the names were so similar. And so when I sent out my invoices just last month, I got an email from this person who said, why are you sending me a bill? I never hired you. And I went back and I looked, and I talked to Brandon, and I'm like, what's the deal? And he's like, oh gosh, we figured it out, and like moved the record over to the correct client. But that's just one example of, somebody whose business name looked a lot like somebody else's, got an unsolicited bill. Normally I'm a Boy Scout about billing, but like that one slipped through the cracks because somebody wasn't dealing with the trademarks appropriately. So.
Yeah, and Bettina, I mean, the examples are just rife. So I've worked with clients. I don't have their permission to talk about their what they went through in detail, but have worked with clients, and they have found that there are 5 or 6 other travel advisors that are using names that are just so similar to theirs. They may have registered, for example, a domain that uses a dash between the two trademarked terms of my client, and think that that's enough to distinguish them. They may use, as I mentioned, like Huckleberry Travel and Huckleberry Travels, while different, are not different enough. I would say Huckleberry Travel Advisors is not different enough. Huckleberry Travel Company is not different enough because Huckleberry is the actual protected term within it. And I think unfortunately that there are business owners who just may not be as well advised, informed as they could be, and think, well, gee whiz, like they may not run any type of search and may just come up with the same or like confusing, like so similar that it's confusing, that your clients are apt to be confused, come up with a term that is for their trademark that is really like identical to yours or very similar to yours. Or they may have done a search and said like, that other business, they're based in Vermont, I'm based in South Carolina, that's fine. Well, it's not, because you all are working online, and so you're already like working to attract customers and clients nationwide. And so any type of anyone who's working within your field who's using a mark that is similar to yours is engaging in trademark infringement if they have come after you.
Yeah, and I'm just going to put this up because I think it's relevant. Margie, hi Margie. Margie's a client of mine, and she's awesome. Uh, Margie it says, and we covered this early on, but I think Margie might have joined a little bit late. If you're an LLC or you're a corporation, does that give you trademark protection? And I think that goes to what you were just saying, MJ, is that when you register as an LLC, you're registering that name in that state, but that doesn't necessarily provide you with protection for your brand or your logo, right?
It gives you no protection.
Yeah.
Gives you no protection for trademark. You To gain trademark protection in the U.S., you need to put the trademark out there and offer your services for sale. That's how you gain trademark rights. And registering an LLC, even if it's the same name as your mark, is not registering your trademark. If you want to register your trademark, it has to be done within the U.S. Patent and Trademark Office.
And then we got this question. There was another variation of this question when you're talking about budgeting for trademark. But somebody was asking, somebody else asked if do you have a set fee for doing trademark registration? What are we talking about in terms of the expense and the cost to budget for this?
So trademark registration in the U.S., we charge a flat fee because we know exactly what happens every single time, and generally are around $1,850. And that's for preparing and filing your trademark registration all the way through to registration. And except unless there's some major objection to it, then that's a separate cost. But the base cost is $1,850 to register your mark.
Okay. And then we've got this question from RSC Vacations. Is the term vacations just as broad as travel? So if you've got a business that's called Luxury Vacations, that's not going to be something where you're going to be able to trademark it because lots of people sell luxury vacations, right?
Exactly. But let's say, and this is a question that's coming from RSC Vacations. Let's say it's coming from RAC Vacations. So I'm not giving specific legal advice to the gentleman who joined us. The RAC in that mark is very likely protectable, whereas vacations is not. And so if you do file, for example, for trademark registration, you would do what's called disclaim exclusive rights to the term like vacations or travel, but you would have protection for the mark as a whole, but without seeking or gaining exclusive rights to that descriptive term vacations.
And then we've got a question from Jillian about, is it a timing issue? By being the first person to use that name, does that give you rights? And what about dormant names, the businesses that may have been even registered at one point in time, but they've gone under and they've shut their doors for good? What about that?
It's a really great question, Jillian. Thank you so much. So it is a timing issue. The first to the marketplace gains the rights, but to underscore what we covered a little bit ago is that you're obligated to continue to use your mark. And if you don't use your mark, you don't use your mark, you can eventually lose the rights. And under US law, a mark is abandoned if it is out of use for 3 years without any intent to reestablish use. So a trademark is considered abandoned if it hasn't been used commercially for 3 years. And so that, I think Jillian was talking about, would be a dormant mark, and those trademark rights are lost.
Okay. A couple of other things. This is from Gina. She wants to know, are there pitfalls to filing a trademark on your own, or do you need to use a lawyer to file a trademark or copyright? I'll just say this, that, I know people who have registered their own trademarks and have done it successfully. It is also such a specific area of law. I mentioned this earlier in the webinar, that I'm a lawyer and I would not do my own trademark because I'm not a trademark lawyer. And there's just a lot that goes into it. And I don't know, MJ, if you want to talk a little bit about some of the complications. We were talking in advance of this call, and you were talking about somebody who was trying to register a trademark, and there were like 1 million people in line before them.
Absolutely. So, the pitfalls are that your application may not be as beneficial to your business or not. One thing is that you cannot add to your list of services after filing. So if you forget something or don't realize that you would be eligible to gain actually broader trademark protection, you can't add to the list of services after filing. The other is that you may, if you don't engage in a clearance search, you may go ahead and invest in a trademark application, and then there is someone already has those rights to that mark, and their rights are senior to yours, and that's something that an attorney could have identified for you. But if you do go ahead and file your trademark application, one thing is that one point that you may want to definitely work with an attorney on is if you do get an objection. Like Tom mentioned, I'm working with a client who, it was only years and years later, I think they began their business in 2017, and it was only last year that they really felt they needed to register their rights because they were encountering so much infringement. They wanted to file an application so that somebody that they contacted and said, like, hey, you don't have rights, they wouldn't feel like they could be cute and try to register before her. So she got an application on file before we reached out to those trademark infringers. But what had happened in the meantime, in all those 7 years, is that others had filed applications for similar marks in the interim. My client ultimately has senior rights, but she now has to spend a lot of time knocking out those registrations for marks that are so similar to hers that the trademark office will not grant her a registration unless those registrations are canceled. So it's something like that I think you most absolutely will want to work with an experienced attorney for. And the other thing I would mention is that this is a reason to, if you can, to register your mark pretty soon after you begin using it, so you don't encounter those problems that my client did.
So we're a little bit over, but we also have a couple of copyright questions. So if you're not pressed for time, let's see if we can just squeeze in a few more really quickly. But before we move on to copyright, Kate, hi Kate, has a question.
So Kate, if your logo does not contain the wording, or you're saying that you can't trade my business name due to it having common words. So if it's common words, in other words, like descriptive terms that we've talked about are not eligible for trademark protection, then absolutely, it's a really smart strategy to seek a trademark registration for your logo. And what would happen in the same way that I mentioned that, so for example, if Tom's Travel Agency had registered its mark, the term travel would be disclaimed. the terms that are descriptive within your mark would be disclaimed, but you would have protection for that logo. You would have a registration protection for that logo as a whole. So that's a really smart strategy to gain a registration.
Okay, let's just see if we can burn through a couple of copyright questions. Canva is a tool that a lot of travel advisors use to, do Facebook, social media posts that look slick, flyers for maybe group trips that they're doing if they're doing a Come With Me trip. If you're using an image that you acquired through Canva, my assumption is that you're buying a license when you do that, or it's a royalty-free photo that they're providing to you.
That's my assumption. That's my assumption as well.
Okay, and then if you do get a request to, a shakedown letter saying you owe me money because you're using my picture without permission, can you get out from under that just by removing the image?
Generally not. I mean, you will absolutely want to remove the image, but think about it from the other side. If you took a photograph and somebody was using it without your permission and you're protected under copyright law, and if you're hiring an attorney who wants to be paid by you, typically they're not going to be satisfied simply by your taking down the image.
Okay, and then one more. Does using the copyright symbol, the little C with a circle in it, does that symbol give you any additional protection? We talked earlier about just by publishing the website, you have copyright protection by being the person who put it up there first and being the author of it. But does it add anything to use the symbol?
The symbol does not add anything. It is giving notice to the world that you are aware that the content on your website is protected under copyright law. And Bettina, my guess is that you and most everybody else here today knows that the R with the symbol around it can only be used when a work is registered, whether it be copyrights or trademarks.
Terrific. So I think we're pretty much at, I'm obscuring the final slide here. I've had MJ's email address scrolling at the bottom of the webinar. If you want to reach out to her about questions you have about trademarks or copyrights, email is the best way to do that so that she can check and make sure that she doesn't have a conflict. If you have questions about other travel related things, independent contractor agreements, terms and conditions, website terms of use and privacy policies, all of those things, my firm would be more than happy to talk to you. And if you're viewing this webinar, you're probably viewing it either on my Law Practice LinkedIn page or my Law Practice Facebook page, which is how you can get in touch with me. Our email address is there on our website. So MJ, thank you so much for doing this. I'm seeing all of the comments that people are just really over the moon about having this information. So I'm very grateful to you for taking time out of your Friday afternoon to do this, and we'll just wrap it up here, I guess.
Thank you, Tom. Thanks, everybody.
Thanks all. Take care. Bye-bye.